So I think we can start now. Good afternoon. It is a great pleasure to welcome you today to the Nova School of Law and the Nova Consumer Lab for the sixth talk of this series of talks. We have a great panel today. I particularly thank Jiangqiu and Geraint Howells for their willingness to join us from afar and participate in this event. Today we will talk about e-commerce in the European Union and in China. We have with us Natália Galvão Veiga Rebelo, who is a researcher at the Nova Consumer Lab. Natália works also as country legal manager at IKEA Portugal. Jiangqiu is an assistant professor at Fudan University in Shanghai, China. He's the author of the book A Comparative Analysis of Policing Consumer Contracts in China and the EU, which corresponds to his doctoral thesis completed in 2017 at the Maastricht University. Thank you so much. Geraint Howells is Executive Dean and Established Professor at the College of Business, Public Policy and Law of the National University of Ireland, Galway, and Visiting Professor of Commercial Law at the University of Manchester. Thank you also so much. We will certainly have a very interesting event. We will have two presentations followed by a commentary by Professor Geraint Howells. At the end, we will have a short debate. Feel free to write your questions in the chat or use the raise hand button at the end. Without further delay, I now give the floor to Natália. Natália, the floor is yours. Thank you very much.
Hello all, thank you in advance for being here and listen to our talk about the e-commerce regulatory framework in the EU and in China. I would like to say that I'm deeply honored and humbled to have the privilege to discuss this subject with Professor Jiangqiu, Professor Howells and Professor Jorge Morais de Carvalho. Thank you for this opportunity. So I will share now my presentation. I believe it is okay, Jorge? Yes?
It is okay, thank you.
So to begin our journey through this comparative analysis, I underline the significance of online cross-border trades in the current time, which have now obviously a bigger impact due to COVID-19. That is clear from the graphics and from this information that I'm presenting. We will have more and more situations of consumer contracts being agreed between a domestic consumer and a foreign trader. This increase in cross-border trade raises the need to know more about consumer law in different jurisdictions. And it's obviously there is a great interest to understand the ways of the main markets, as it is the markets of the EU, and a main global player as it is China. We are all aware there is a great effort being made by the EU to protect consumers. In Portugal, our main diplomas comes from I'm sorry, I'm having here a technical problem, comes from EU directives. So as you can see from these graphics that I'm presenting, and let me just change here yes. We live in a country particularly exposed to the performance of non-resident operators, namely China, since 85% of the online purchases from the Portuguese are cross-border purchases. And of these 45% come from China. So China is obviously also the world's largest manufacturer, and the internal market of the European Union is a relevant reality. As Professor Jiangqiu says, the experiences and problems that one jurisdiction has suffered may also inspire or help others. So we can in this way understand how to achieve results to discuss a better and more complete understanding in what concerns consumer law, using different solutions or understanding other ways and reasons. So this talk aims to analyze certain differences and similarities regarding consumer law in what concerns e-commerce in China and the EU, and maybe guide us to understand different models and allowing us to learn within this process. So concerning the European Union, I have here the main applicable framework that I'm sharing. So as we know, in 1997, we can see the foundations for the regulation of e-commerce by Directive 2000/31/CE. The European Union has positioned itself at the forefront of the regulation of consumer rights and in the promotion of the e-commerce sector. This directive, though, was not intended to the reality that we have now concerning platforms. This is obvious. It wasn't a reality in 1997. Actually, the concept of platforms began to be studied in 2001 with the notion of multilateral and bilateral markets. This directive establishes harmonized rules on issues such as transparency, information requirements, limitations of liability, and so on. This directive also sets out that member states cannot impose a general obligation to monitor the information transmitted or stored. There is no an obligation to control. This is also being used, obviously, by platforms to respond to issues about liability. Here, the topic of influence and neutrality of the platform is of a great importance. Nevertheless, we all know that big things are happening in the EU. As part of the European digital strategy, it was announced that the European Commission would upgrade the rules governing digital services in the European Union. And the European Commission proposed two legislative initiatives, the Digital Service Act and the Digital Markets Act. So we can now expect new obligations on traceability of business users in online markets to help identify sellers of illegal goods, for example, and the reinforcement and further clarification of the conditions for liability issues. As we know, the topic of platforms, it is a big reality today in the EU. We have more than 10,000 platforms working, so this topic is of a great importance. This proposal of the European Commission also establishes the need to monitorize and of due diligence of the platforms in what concerns illegal contents and services. Platforms will also have to clearly identify the merchants, having here an important role in what concerns topics such as counterfeit goods. As you can see from this slide, we have several other big and important directives and regulations. For instance, the protection in unfair commercial practices, the one that establishes measures for distant and off-premises contracts, and new ones, the 770 and 771, the regulation 2019/1150 that has a great focus on information and transparency, and the directive 2019/2161 with the modernization of European consumer law, integrated into the New Deal of Consumers that is going to be enforcing all the member states from May 2000 to 2022. So we have major diplomas here in what concerns the applicable framework in the European Union. In what concerns China e-commerce regulatory framework, I have identified three major diplomas that you can see in the current slides. The law of the People's Republic of China on the protection of rights and interests of the consumer, that is in force since January 1994, but it was substantially altered in 2013. We have the contract law of the People's Republic of China of 1999, and the e-commerce law of the People's Republic of China, which is quite new, in force since January 2019. I say it's quite new because the COVID year is almost a year that didn't happen, so I would say it's quite new for everybody. In what concerns, I will now analyze the first law that I mentioned here, the law of the People's Republic of China on the protection of the rights and interests of consumers. So in 2012, taking into account that the online retail turnover reached huge amounts in China, the Chinese government took the first step to address the online shopping issues by means of a new Chinese consumer protection legislation. This was the first revision to the PRC law since it was past 20 years from its effective date. I will go down a little bit deeper in the notion of consumer in both realities because I find it quite interesting, this discussion. In what concerns the definition of consumer, the Unfair Contract Terms Directive and the Distance Selling Directive, they recognize consumer as any natural person who is acting outside his trade, business, or profession. So they have the exactly same definition, and it is a quite similar definition that we have in all our EU legislation. So this European notion of a consumer could also be described as a negative definition. A consumer is defined by the nature of the transaction, not being related to that person's profession, trade. In contrast, this is quite interesting for me. The Chinese notion of a consumer, as laid out in Article 2 of the Consumer Protection Law, is quite different, as it is not a negative definition, and rather it seeks to positively define a consumer through limiting coverage to daily consumption needs, which I find it very interesting. It is apparent that the Chinese notion of a consumer does not follow the EU. Not only is a consumer defined positively, but mention of the potential business or trade purpose is also completely missing from this China's definition. In what concerns this topic, I found it interesting to understand how the Chinese courts would handle this issue. In fact, the key notion of who may qualify to claim as a consumer has been considered in guiding cases issued by the China Supreme People's Court. Just for you to understand a little bit, the guiding cases system is a device in China through which the Supreme People's Court wants to improve the quality and consistency of judicial decision-making in lower level courts. And they select and publish a number of guiding cases that must be considered by a lower courts in subsequent cases. So I find it quite interesting. A specific case, which is 2355, where we have someone that goes to a supermarket and buy 15 packages of sausages, 14 of which were past their expiration date. Just for you to understand, the food safety law provides that the seller should pay 10 times the purchase price of any food which does not conform or does not comply with this legislation. So, however, for you to be eligible for this claim, you must be qualified as a consumer. Obviously, the supermarket did not accept this right away and stated that this person did not fall within the definition of a consumer from Article 2 of the Consumer Protection Law, because it was clear that the purchase of these goods was had the only purpose of getting the compensation. And it was not for the needs of daily consumption, as we see in the definition. However, this court specifically found in favor of the person who bought the sausages and awarded him the full compensation of 10 times the purchase price of the goods. This judgment focused on whether the supermarket could prove or not that the purchase was made for a commercial purpose, such as resale or production. As they failed to prove that, this person was considered a consumer under this Article 2 of the Consumer Protection Law. So as you can see, even if the definition is quite different, we have in court the same reading of the situation in what concerns the understanding of the purpose of the purchase. The definition was not altered in the revision, even though it was quite criticized by the academic world due to its difficult applicability. I saw several criticisms concerning this topic in my research. So a little bit about now the right of withdrawal in what concerns this topic. This was introducing this alteration in the Chinese law in order to strengthen the consumer's position in long distance sales. As I stated previously, they had reached huge numbers in what concerns e-commerce already in those days. So the consumer was then entitled to return the goods, this is in China, within 7 days from the receipt. So taking into account that the consumer has no contact to the goods when the purchase decision is made, the intervention of the law is obviously of a great value and has a huge impact in the promotion of the online shopping and in the confidence of the consumer towards merchants when they don't have the possibility to see the good or to be in the store of the merchants. In Article 25 of the Chinese Consumer Protection Law of 2013, consumers have then the right to return the goods within 7 days. As you know, in what concerns the EU, we have a cooling off period of 14 days regulated by Article 9 of the Consumers' Rights Directive, Within this period, consumers can withdraw from a distance or off-premises contract, as we know. It is a maximum harmonization rule, so 14 days is mandatory to every member state in its national laws. It is clear the focus from both jurisdictions on the protection of the consumer in distance sales. In both China and the EU, legislators consider that withdrawal rights should not be applicable to all commodities or services. And just here's something, in China, it's not applicable to services at all. And the EU, as you know, it is. Professor Zhu is now going to introduce a little bit about the new e-commerce law in China, but I would like just to finalize this presentation with a few words about it. So in 2019, China has a new e-commerce law that came into force in January 1, and that seeks to regulate online business, protect intellectual property rights, which is a big topic in China, and increase cybersecurity. This new law is applicable to platforms, operators on platforms, and online sellers. So since 2019, platforms operators must do due diligence to ensure that goods sold by third parties, merchants on their platforms are in compliance with the updated legal norms. Previously, this is also something interesting, online stores of individuals did not need to register as industrial or commercial operators. According to this new law, they must register and pay taxes. So maybe here a big impact in prices also. So the e-commerce law also defines the responsibilities and obligations of e-commerce operators, the protection of intellectual property rights, and it had some notes in what concerns sustainability, which is obviously a very real topic nowadays, in what concerns packaging, the logistics system of the e-commerce. For these environmental issues, the law stipulates, for example, that the logistics service provider shall use environmental friendly packaging materials, being according to all rules, recycling packaged materials, among others. This is in Article 52. So just to finalize, we can see here a great effort being made to regulate the topic of e-commerce according to the current times by both sides. China, with this new revision in 2019, and the EU, with now these new regulations that we are going to have that are altering prior legislation. I finalize by thanking everybody for listening and by saying that it is not much, because in 15 minutes, it's not enough for us to talk about this topic. We would need a one-year course, I would say. But I'm available for any questions or discussions that can arise from this presentation. Now I give the floor for Professor Jiangqiu, whose knowledge I'm very eager to listen and to interiorize. Thank you very much for this opportunity.
Yes, thank you very much, Natália. And now, Professor Jiangqiu, thank you very much for being here, and the floor is yours now.
Excuse me, could you see this?
Yes.
Yeah, excellent. Today, I would also like to thank all of you to have me here to introduce Chinese e-commerce law and to share what I know, and also maybe I will focus on a very specific topic to the Chinese approach to regulate customized search results. So I will divide my talk into two parts, and the first one is about a brief introduction to the Chinese new e-commerce law, like Natália just mentioned, promulgated on 2019. And then I will just use an example to share how the Chinese e-commerce law works. And this topic is about regulating customized search results. Okay, so firstly, I would just give a brief introduction to the law, and you will see that they have 7 chapters, and the first one is about a very brief introduction of general rules, for example, the good faith, right? And also the second chapter is pretty important, I would say, because it gives the definition of the e-commerce business. Because Natália has mentioned the Chinese consumer law promulgated, actually revised on 2013. So they give the definition of trader or business and consumer in Article 2 and 3, in Articles 2 and 3. but actually there's no definition on e-commerce business regulated in this law. But in the Chinese e-commerce law, the situation is different. You always see that they have a very detailed definition for e-commerce business in Article 9, and its second paragraph mentions actually what is an e-commerce platform business. It is pretty much important because actually a lot of people in China, they have mentioned that this law, it is not about, or we would say it is not majorly about the e-commerce business, but more it is about e-commerce platform business. Because you know that there are several very big like e-commerce platform. For example, Taobao, Alibaba, you have known that, right? And also Jingdong, right? So they do not sell a lot of things they like produce themselves, but actually they provide a platform for people to trade on the platform. But actually they have collected a lot of data and also the trading materials and resources and information, and actually they have very great power. So this law, it is designed or promulgated to deal with these issues, actually revolving actually the common e-commerce platform business. You will see this is the definition. And in also chapter 2, you will see some articles about the rights and obligations, or say the duties. For example, I gave 2 examples, and the first one is also mentioned by Natália. It is about the e-commerce business. They all have to make market participant registration, right? And they have to pay taxes. So Natália has also mentioned. And also you will see Article 38 is pretty interesting, I would say, because it has a very huge debate in China as well about actually the e-commerce platform business. They have this kind of duty to guarantee like the personal and property safety of the consumer. Otherwise, they have to bear joint and several liability. And also in second paragraph, you will see that they have to perform the duty of reviewing, the qualifications of like in-platform businesses. They have to check, right? They have to check like they're doing right business. They have all like required license, right? If they haven't performed this kind of duty or obligation, they have to bear corresponding liability. You see, this is an article actually give a very high or very important duty to the platform. They would say that like you cannot just like step aside and just collect the money from the trades like occurring on your platform, because actually all these trades, they're on your platform. You have to be responsible for them, right? At least you have to make sure that you have already reviewed their qualifications, necessary qualifications, right? There are some also duties and obligations, maybe we will mention later. And also you will see, for example, Article 40, it is about another obligation. They have to indicate advertisement for commodities or services ranked as a result of pay-for placement. I think this is also a very important issue in the European Union as well, right? And also Natália has also mentioned the duty to protect the IP rights, right? You will see Article 42. They say the IP rights holders, they have this kind of right to notify the e-commerce platform business of taking necessary measures if they have witnessed actually there is some kind of infringement on this platform. And after that, the e-commerce platform business, they show after they have received this kind of notice, they have to take timely and necessary measures and forward the notice to the in-platform business, right? You will see, so it is a kind of detailed rule to protect the IP rights holders, like legal rights and interests. And third chapter is about the formation and performance of the e-commerce contracts, because it is kind of different, right, from the normal contracts, I would say. So they have provided several like detailed or specific rules for like e-commerce contracts. For example, you can see this Article 48. They say a party shall in e-commerce be presumed to have corresponding capacity for legal conduct, right, unless contrary evidence is sufficient to rebut the presumption. Because you know that, like, I think this is not only like question or issue in China, because there are some like teenagers or kids, they use their parents' like accounts to play games and to buy like in-game purchases, right? And also to buy some like services and commodities. But in these cases, it is very difficult for the e-platform business to discover their kids, their teenagers, right? They don't have this kind of like civil capacities for juridical acts, right? So this is a German term we learned from the Euro. So in this case, they say like in this kind of situations, they are presumed to have corresponding capacity for legal conduct. This is chapter 3, and chapter 4 is about the settlement of e-commerce disputes. So they said the e-commerce business, they have to provide the original contract and transaction records. So you are the trader, you're the business, right? So you have more power, or you have the better situation to save this kind of records, right? So if a dispute like occurs, you have to provide this kind of evidence. You have to provide this kind of information. So what is your original contract or transaction records or record? If you cannot provide this kind of information, you have to bear the disadvantage like results, right? So I think this is kind of interesting as well. Promotion of e-commerce is about the national's duties, right? The government's duties. It is not a very important part, I think, in this piece of legislation, and no many articles regulated in this part. But chapter number 6, which is about the legal liability, is definitely very important, I would say. So you will see, for example, Article 83, right? For example, we have mentioned Article 38 of the law, right, which is about the e-commerce platform business, their obligation to review the qualifications of the platform businesses, right? If you fail to perform this kind of obligation or duty, what kind of legal consequence will be, right? You will see Article 83 of this law mention that the government branch, actually, they can impose a fine, right, in some situations, and they can ask the business to pay a very high fee, very high fine, right? And there are some also supplemental provisions. I would say this is a very brief introduction of the structure of the Chinese e-commerce law, right? So I think there are several important parts, especially the articles regulated in chapter 2 about the obligations or duties of the e-commerce businesses, especially the e-commerce platform businesses, right? So the rest of the time, I will just use an example to look a little bit into this kind of question. So this is about customized search results. So what is that? These examples, they're all in Chinese, but I think from the picture you can see, like if you use different cell phones to make like order, right? Actually, you will receive different prices. If you use an iPhone, you will see actually the price is 52.1 yuan. And if you use an Android phone, you will get or receive a lower price. It is only 46, right? I think this is not the only issue in China as well. I think it's also happened in, for example, the US and also the EU. But in China, many consumers, they discover this kind of thing and they say, no, this is not fair. And we won't accept this kind of business practice, right? So in order to respond to this kind of business practice, there is a very specific article in the e-commerce law in China. It's Article 18, paragraph number 1. They say, when providing the results of search for commodities or services for a consumer based on the hobby, consumption habit, or any other traits thereof, the e-commerce business should provide the consumer with options not targeting his or her identifiable traits, and respect and equally protect the lawful rights and interests of the consumers. So this kind of obligation, we can say it is an obligation to provide neutral search result, right? If you fail to provide this kind of result, so the legal consequence we have mentioned regulated in chapter number 6 of the law is Article 77. They say if they provide such result in violation with this article, right? So actually the administrative authority of market regulation, they have the power, they have the authority to ask the business to take corrective action in a specified period, and also confiscate any illegal income, and may fine it not less than 50,000 RMB, which equals to, I think, it's a very great amount of like euros, right? You will see that. So this is a very serious consequence. So it is very interesting article, I would say, because they have some like interpretation question behind that, right? For example, the first one is how to understand trade, because we can know that this is targeting actually the price differentiation, right? So you use different phones but receive different prices. So how about the other trades, right? For example, the device information we have mentioned, and also the consumer's hobbies we have mentioned, the behavioral preferences. So this is also targeted by this article. So I have a question here. So should natural or neutral search result be provided or in all like circumstances happen in the e-platform businesses? I think this is a very interesting question, because you will see that like in many situations, they did not give you different prices. They just put, for example, like a shop or a commodity you have bought, but at the top of the page, right? They say, okay, this is the commodity. You might be interested because you have purchased from this shop, right? But this actually falls into the scope of Article 18, paragraph 1 as well. So this is very interesting. So whether this kind of situation should be regulated as well. So this is my first question. And also, I would say, even if they gave you a different price, in many situations, I think it is acceptable. It is no problem, because actually the price discrimination, it is widely seen like in the past. For example, the third degree price discrimination, and also the second degree price discrimination. For example, we give discount to new customers, right? We give discount to old people and also the students, right? So we didn't say there is a problem here. So why we give different price to different people on internet? So this is a very problematic issue. And also in the past, we also would say like some people, they spend more time to think about whether they want to purchase from a shop, right? But like in the business area, in the e-commerce era, so why we say this is forbidden? So we cannot give lower price to people who spend more time on thinking about whether he wants to buy the commodity or not. So I think it's a kind of like against the economic rationale behind that. So I would say it is necessary to like narrow the applicable scope of Article 18, paragraph number 1. So I would say its legislative objective, or we say the aim, is to protect the consumer, right? So I would say only the situations that the consumer's legal rights and interests, they're harmed or infringed. So only in these situations, actually, the law should intervene, right? Actually, these only this kind of behavior should be corrected. So this is my suggestion. So I think this is also can be based on the interpretation of Article 18, paragraph 1 as well. So only the consumer's right to know is infringed, or the consumer's right to dignity is infringed. So only in these two situations, actually, the Article 18, paragraph 1 can be applied here. So the first one referred to the situations that, like the trader, they haven't disclosed the relevant information factually and comprehensively. For example, they give you a very short time. They just limit your opportunity to compare the prices, right? So they infringe actually this kind of right to know, right? Only in this situation, I think Article 18, paragraph 1 can apply. And also another situation is like the consumer is substantively discriminated. For example, you're young people, but they only give you the the results the young people can see, right? You can say like the age discrimination should be forbidden, or the sexual discrimination should be forbidden. So you have to provide me all the search results, but not only the results for men or women. So this is my suggestion. A very brief introduction to Chinese e-commerce law and Article 18, Paragraph 1 of the e-commerce law. Okay, thank you very much.
Thank you so much, Jiangqiu, for your great presentation. And now I will ask Professor Howells to comment on this topic. You just need to turn on your microphone on Zoom.
Thank you. Hi, cheers.
Thank you.
Well, many thanks again for
much.
inviting me to this series of lectures, and it's been really interesting for me to catch up on the developments in e-commerce law, both in Europe and in China. And it's great to be at the Nova Law School. I've actually once taught at the Nova Law School in America. I don't know if you know, there's another Nova Law School in Fort Lauderdale, America.
I didn't know.
So it's great to be at the second one. And there's also a big debate at the moment about whether we can do away with traveling for the sake of the environment to conferences and have events like this. And actually, I don't always think that's a good idea, but today's event is showing how well these sorts of events can take place online. And we had two very clear and wonderful talks that I learned a lot from. So I'm going to make some random comments about this area of law, and maybe that could then lead on to some discussion afterwards. So just a few points that came to me as the talks were taking place. I think it's interesting to see the amount of cross-border trade and how some countries are more dependent on cross-border trade than others. I was previously working in Hong Kong, and I had a PhD student who originally came to study e-commerce laws in Hong Kong, but soon found that actually there weren't that many Hong Kong platforms or online businesses, because many of them were simply using the Chinese businesses, and she switched her study focus to the Chinese sector. So that's interesting to see which countries are dependent on cross-border trade and which countries are dependent upon the importation from China. Now, one issue about that, of course, is that it's often alleged that the Chinese trade is facilitated by the International Postal Union rules, which give very low postal rates for products coming from China compared to products being posted from, say, the United Kingdom. So when I worked in Hong Kong, my first idea was to write all my Christmas cards and post them back to England when I landed in England at Christmas. And then I realized it was actually 4 times more expensive almost to post a letter in England than it was to send it from Hong Kong to England. So I think, you know, that's one issue which I think will come under scrutiny as we're talking about global competition between nations, and whether China will keep that privilege, I think is something that's going to be debated. Then the issue about traceability, I think, is an interesting one, and what we see really is the obligations being imposed upon online platforms, and you see this very clearly in the Digital Services Act and the Digital Markets Act, as Natália told us. Actually, there are other rules as well, which I think we can talk about here. So I think the market surveillance regulation imposes obligations on fulfillment service providers to check that products comply with European regulations, and also brings duties of cooperation into place for information society service providers. You see through the rules, the model rules being developed by the European Law Institute on platform liability and more recently on product liability, suggestions that platforms should take responsibility for the products they have. And there's an interesting case in America called the Oberdorf case, where I think it was a Court of Appeal of Pennsylvania said that platforms were liable in products liability as a sort of supplier, and that caused great shock to many in the e-commerce world. Now, that case, I understand, was settled on appeal, but there are other cases which have gone the other way as well. But it's an interesting question as to whether the participants in the platform will become part of the network and have the liabilities associated with that. I think it may be particularly true in the 3D printing world, where you have platforms which make, for example, 3D print products, and whether they get caught by product liability laws or not, I think will be an interesting to consider going forward. On the rights of withdrawal, I think it's interesting that China has adopted right to withdrawal. One thing I noticed when I left Europe to go to Asia, and then I also looked at Australian law a bit more closely than I had in the past, is that the right to withdrawal is far less developed in many parts of Asia than it is in Europe. It's almost become a part of our DNA, our consumer DNA, to believe in the right to withdraw. And there's an interesting discussion paper by the Hong Kong Consumer Council, where at one time in Hong Kong they proposed a very wide right to withdraw, and in this more recent one they actually said there shouldn't be a right to withdrawal, particularly for internet contracts. And they talked about wanting to encourage the platforms, and particularly given that many of the things bought on those platforms were of low value, that there shouldn't be a right to withdrawal, which may stifle the industry and stop it developing. Personally, I think if the concern is for low value products, you can have an exemption for first, 50 euros or something like that. So I don't really agree with the Hong Kong approach, but it's interesting that they'd actually taken the internet as a particular case study and come to the conclusion that it shouldn't be covered by the right to withdrawal. And so, again, I think that's something we might want to consider. And again, more generally, the right to withdraw is coming under criticism from two sides. Some people who believe that you can use big data to personalize law better and then more fine-tune the right to withdrawal, including in some cases not enforcing it on parties. And also, I noticed you've got a conference on the sustainable consumption, and some people argue that the right to withdrawal goes against sustainable consumption because you allow people to reject goods for no reason, and all the sort of duplication and transportation and effects on the environment from that. So that's his debate. Personally, I still believe in the right to withdrawal. I'm going to write a paper trying to defend it at a conference at Chinese University this summer. But I think there's an interesting debate for us to have. I think, again, we mentioned the guiding cases in Hong Kong, in China, the so-called Wang Hai phenomenon, the idea that people are private, almost corporate private defenders of the consumer, going around finding products which don't comply and are using the law to recover multiple damages. Well, what I picked up on, and I would like Professor Guy's views on this maybe, is that there's a lot of different opinions on this approach to enforcement, and the courts themselves aren't always very consistent. Sometimes they're saying, look, this is like a real knight in shining armor, like almost like the American trial lawyer who's cleansing the marketplace by bringing these actions. Other times they're seen as people who are disrupting the stability of the economy unnecessarily by taking this action. So how that plays out, I think, will be very interesting going forward. I thought it was interesting that the Chinese law had dealt with this issue about children using it and their capacity and so forth, because most legal systems have some rules on capacity, and it's true that internet sellers could get caught out. They could provide things to juveniles and not then be able to recover the money. And I think it's an interesting issue, this, particularly to what extent there should be a duty to check the identity. How far should they go? Particularly when you think about things like loans being offered over the phone. I picked up in Scandinavia, there was a big issue of youngsters. Often they were older than 16, but still quite young, going out, partying, texting for money to spend the night in the nightclub when they'd run out of cash. And I think there might be some need to have some balance there, but I don't know quite how to strike that. And then on to the personalized pricing issue, which I think is is very interesting indeed. A few years ago, I read a report which said actually this is talked about a lot, but it's not often the case that there is this discriminatory pricing. So I don't know. I mean, it'd be good to see how much of it there is. I don't know if it's discriminatory price, but I once went on a very well-known website to buy a break for my family from Hong Kong to Malaysia, to a very nice island in Malaysia. It was the same website. One was the UK-based version, one was the Hong Kong-based version, and the price difference was 4 times the price in one than the other. So, you know, even with the same person booking it through the internet, there were vast differences. And I guess they thought the price someone in Hong Kong would pay for that would be a lot less than the price someone would pay if they're booking that from the UK. But so that may be an example of the discriminatory pricing. But we also get this in the real world, don't we? You know, for many things we all pay the same price, but for some things we don't. Some things we are accustomed to negotiating for. Cars being a good example, and very few of us pay the list price for a car. We'll go in and try to negotiate some discount or some extras to be added to the car. It may be how good you are at negotiating matters. It may be how much they value your custom. And there's, of course, some famous reports showing that that's very discriminatory. And indeed, there's an issue, I guess. We always assume that the internet is blind to all sorts of discrimination. But of course, we know that behind the algorithms, they've collected data, and so they may be making discriminatory calculations based on what they assume we are. And to what extent that really plays out is going to be interesting. And again, it goes back to the idea of personalization. I mean, I mentioned before, but one thing that's being pushed a lot at the moment is the personalization of laws based on trying to match up with people's preferences. But in some ways, if you look at some views of contract as a balance of different rights and obligations, you know, whether you have a different price or you take away a legal right, they can be seen as mirror images of one another. And so, to what extent we allow people to personalize their deals, either if it's directly in price or through the sort of package of rights and obligations you get in return for the price. There's interesting questions there. I myself think it's interesting that they people who argue for personalization of law are also people who've been writing about behavioral economics. And of course, behavioral economics teaches us that we don't really value our legal rights enough. So many people will be willing to bargain away their right of withdrawal for some small discount or some extra freebie. But whether they're really getting the right decision that really matches their preferences, I think is interesting. And I think the other issue that we've got is, I just put on the table, is about recommendation reviews. A lot of interesting work going on about those. And again, this is to some extent tied in with the idea of the ability to use the internet in a positive way to match our preferences, because if we can use the recommendations as a way to make better choices, that's good. But of course, a lot of issues about whether reviews really do give us information. They're sort of one form of information, anecdotal, the things that you may take into account, but should you give them as much weight as they are? Should you at the very least have some structure around them? And I think Christoph Busch is talking at one of your seminars, and he argues there should be some sort of standardization so that a review collects data in certain ways and presents it in a standardized form, so we know basically what a review is worth to some extent. And I would go along with that. And another issue I mentioned, because Professor Guy is here and my student in Hong Kong is working on, is a practice of brushing, where I understand it's a practice, I don't know if it goes on elsewhere, but where Chinese companies sort of send out products and then give favorable reviews about products in order to get better sales and better reviews. And I'm told there's a big crackdown on that in China at the moment. So it'd be interesting to hear Professor Guy's views on that. So I hope with those comments you can show I was provoked by the two talks and to have some reflections. And I'm looking forward to hear the views of other people about these topics. Thank you.
Thank you so much, Professor Howells, for your great comments on this thoughts in this topic. And now I will ask Natália and Jiangqiu if they want to answer. I see Fabrizio Esposito with the camera. I don't know if you want to ask something.
Jorge, I actually
right
had
now?
here a comment after I heard Jiangqiu about all the obligations that are now imposed to the platforms, taking into account the new e-commerce law in China. I asked if there is no definition of which platforms have these obligations, because in the Digital Markets Act, we have now the figure of the gatekeepers, no? And in this figure, they have plenty of obligations that other platforms won't have. So is there any difference that is made between platforms, being a small one or a really big one? As you stated, there are several, 2 or 3 huge ones in China. Is there any difference?
Thank you.
Yeah.
Jiangqiu.
Yeah, thank you very much, Geraint. Thank you very much, Natália. I think you gave me great comments and questions. So I would say, for example, the like different treatment to different platforms. I think this is, of course, one very important like issue in China as well. But I would say like the legal toolbox or the legal approach, it is kind of different. For example, like in the Chinese e-commerce law, so the rules like regarding, for example, rights and obligations, they're applied to all platforms. So there's no this kind of difference. For example, Alibaba, so you have a very high, for example, criterion to perform this kind of like duty, or other small platform you have a very low. No, there's no this kind of like thing. But the problem is we have a lot of different for example, piece of legislation, and also the piece of regulation provided by, for example, the National People's Congress. So they're not law, but sometimes they're also very important. For example, I think just 1 month ago, so they have promulgated a very new one, so promulgated by the Antitrust Council of the National People's Congress. So regarding issues on platform, e-commerce platform, antitrust issues. So for example, the personalized search results, like we have mentioned, we have discussed, like in this issue, Article 18, paragraph 1. So it is also mentioned in that piece of legislation. But like if you apply that kind of approach, so there is a precondition. So it is the antitrust regulation, right? So yeah, you have to have like dominant rule, like in the market. So this kind of rule only applies to, for example, Alibaba or Tencent, right? So if you're a very small platform, so this kind of rule does not apply to you. So I would say this is also a very important perspective to observe this kind of issues. I would totally agree, like some kind of conduct or business practice, it has very different meaning, like to a very big, very huge, like e-platform with dominant rule, and another very small platform. I think sometimes it's different. And even, for example, to the issue we have mentioned, like the personalized search result or personalized the price, this is the same. I would say if to a very like, for example, fully competitive markets, so everybody can come in and can compete with others without any barriers. So I would say this kind of behavior is fine, because actually the consumer will choose these like fair traders and honest traders, right? But in some other areas, for example, there's only one very big platform, and they provide this kind of personalized search results. I would say it's totally different. But actually, the toolbox should be came out from antitrust law, but not a very like broad e-commerce law or anti-unfair competition law. In China, we have this as well. For example, Geraint mentioned the fake reviews, right? So we have a very new rule in the anti-unfair competition law. So one article regarding this kind of issue, this is a kind of false information like provided by the trader. So they also have the market authority. They also have the power to impose a fine. So this kind of behavior is forbidden. But this is different from antitrust. Antitrust, e-commerce, and anti-unfair competition. They're different laws.
Thank you so much, Jiangqiu. We still have time for 1 or 2 questions. Joanna.
Thank you. Thank you so much to all 3 of you. I learned so much today. I would have a question for Professor Jiangqiu about the liability of online platforms. You mentioned that platforms have few duties. You mentioned, for example, that if they know that there are products being sold through the platform that are not legal for some reason, they have the right to take them out of the platform. And you also mentioned that there is a duty to know the businesses on the platforms. My question would be, if there is a debate or even rules regarding cases where the platform should maybe not be considered a mere intermediary. In Europe, there is now the debate on whether some platforms have control over the suppliers, and in those cases, maybe they should be held liable almost as suppliers, as Professor Howells mentioned from the Oberdorf case. Also, this idea that maybe some platforms should be liable, not only if they fail at taking things down when they notice things, but also regardless of that, just because they have control over the suppliers.
Thank you very much. Jiangqiu, do
Yeah.
you want to
Yeah.
say something
Yeah.
on this?
Yeah, thank you very much, Joanna, right? So actually Article 38, like in the Chinese e-commerce law, it is a very controversial issue, like also in the Chinese legal academic. So people do not really know like what is kind of the duty to review the qualification and why there is a corresponding legal liability. It's a civil liability, right? So what is actually the idea behind that? So people will say, like in the internet area, they will say, so sometimes the platform, they're kind of similar to like the offline hotel and playground and kindergarten, and also like these kind of public venues. So you're running actually place and you can control it. So you're the master of this area. So you have to be responsible for that. So this is kind of a duty of safety protection, or we say the duty of care, right? So this is regulated in the Chinese tort liability law, and also now in the Chinese Civil Code, the newly promulgated Chinese Civil Code, and also the Chinese consumer law. We have a like Article 20. So actually the operator of like the hotel, the football stadium, right? So you have to protect like the people who came into your like this kind of public venue. So the same idea is used to apply to the platforms. They say you create, actually you open a place for risks, right? And for this kind of like business practices. So you have this kind of duty because you have invested money into that and you earn money from this kind of business practice. So you have to bear this kind of civil liability or responsibility. So if something bad happened on your platform, but actually whether there's some like case already witnessed or already can be seen like in the Chinese practice, in my understanding, no, I haven't seen like a case like based on Article 38 of the Chinese e-commerce law. I can only introduce like the idea behind that, So I think maybe there is another reason for this article is that like usually in China, so it is much easier for the consumer to find the platform than the in-platform trader. So sometimes the in-platform trader, they're very small. So for the consumer to find them, it is very, very difficult. But Alibaba, it is so big and the people there, they're so rich, right? So the legislator, they think, okay, so just to go to find Alibaba people, they have money. It's kind of a deep pocket idea behind that. So yeah, I think these are the ideas behind this article. I hope it helps. Yeah.
Thank you very much. we still have time maximum for one more comment or question. Does anyone want to say something? Probably not. So it's already 2 o'clock, and the idea is for these talks to last for 1 hour, and we are now 1 hour ahead of us. So thank you so much. Thank you so much, Natália. Thank you so much, Jiangqiu, and thank you so much, Professor Howells, for being here. It was really great to hear you and to talk here about e-commerce in the EU and mainly in China. It was really a pleasure to welcome you all here at the Nova School of Law and at the Nova Consumer Lab. Thank you very much.
Thank you very much also for this opportunity.
Yeah, it's really enjoyable. Thank you. Enjoyed it.
Thank you.